Hey everyone, this is William Moore, and you are watching Beyond the Ties That Bind. Thanks for joining me. I pray that everyone's having as good of a day as you can possibly have right now. This is going to be part two and the last part for now. We're going to come back and cover this topic again, but this is part two and the last part for now in the series titled The United States Constitution, or the Failure of the United States Constitution. Now, a lot of people wonder why I spend so much time on the Constitution when I say that I'm wanting to promote freedom. Well, in the Garden of Freedom, it's imperative that the weeds be pulled, or the weeds can overtake the garden. Some of the most dangerous weeds are those which resemble plants which produce fruit. If we go back into scripture, you have Messiah talking about the wheat and the tares. Well, the tares were an injurious weed that resembled wheat in its early stages, and if left unchecked could destroy an entire crop of wheat. So in this garden of freedom, we have to watch out for weeds. We have to watch out especially for those weeds which are imposters. And this is why I spend so much time on the Constitution, because the Constitution is claimed to be a document which secures freedom. It does no such thing. It does not secure or protect individual freedoms. Actually, the opposite. It only serves to protect a strong central government which has power of unlimited taxation. That should be another red flag. So, the Second Amendment is what I want to talk about. Before I get into it, I want to quote Lysander Spooner once again. And yet we have what purports or professes or is claimed to be a contract, the Constitution, made 80 years ago by men who are now all dead, and who never had any power to bind us, but which, it is claimed, has nevertheless bound 3 generations of men, consisting of many millions, and which, it is claimed, will be binding upon all the millions that are to come, but which nobody ever signed, sealed, delivered, witnessed, or acknowledged, and which few persons, compared with the whole number that are claimed to be bound by it, have ever read or even seen, or ever will read or see. And this is so true. If you start quizzing somebody about their knowledge of the Constitution, you'll find out really quick that their knowledge is limited to the Bill of Rights. They have no idea what is contained within the articles, sections, and clauses. So, I want to move along to the Bill of Rights, but before I do that, I want to read a letter which is included in the transmittal to the state conventions, the ratifying conventions. Now, this letter is a part of the Constitution. It is just as much a part of the Constitution as the Bill of Rights. Now, I'm not going to read the whole letter, but I want to go over some of the highlights. It is obviously impracticable in the federal government of these states to secure all rights of independent sovereignty to each, and yet provide for the interest and safety of all. There's that word safety again. So it's impossible to secure all rights of independent sovereignty and yet provide for safety. Individuals entering into society must give up a share of liberty to preserve the rest. So it states that individuals are going to have to give up a share of liberty to preserve what? Interest and safety of all. So what we're confronted with today concerning safety of people and giving up liberty, this is not a new concept, people. This goes back to the founding of the nation, the founding of the United States government. They were already wanting people to give up sovereignty, to give up liberty, for the interest and safety of all. So, what we're going through today is not a new philosophy, it's rooted and grounded in the birth of the United States government. So, the magnitude of the sacrifice must depend as well on situation and circumstance as on the object to be obtained. It is at all times difficult to draw with precision the line between those rights which must be surrendered and those which may be preserved. And on the present occasion, this difficulty was increased by a difference among the several states as to their situation, extent, habits, and particular interest. So he says right here, it is at all times difficult to draw with precision the line between those rights which must be surrendered and those which must be preserved. It's nothing new when you hear people in government telling you that you must give up some of your rights, your freedoms, for the safety of others, the interest of others. It's nothing new. This is something that was being stated by George Washington. He is the one who wrote this letter. So if we go to, this brings us to the amendments. And if we go to the amendments and we're careful to read them, and then we're careful to compare them with what is contained within the articles, sections, and clauses of the main Constitution drafted in Philadelphia, we'll find out that the Second Amendment in particular is not drafted in a manner which gives carte blanche right of gun ownership to own any gun, to own any amount of weapons, and to be unrestricted in the use or carrying of those weapons. We need to look to history and let history define the original intent, which is what we're going to do. There are other amendments in the Bill of Rights which are also worded in a way that protect the government as well. So the Bill of Rights was a compromise because of men such as Patrick Henry, Samuel Adams, George Mason, and Richard Henry Lee. Now, the compromise still worked to be in favor of the Federalist, not the Anti-Federalist. If it would have been in favor of the Anti-Federalists, they would have scrapped the entire Constitution. So, the Constitution was drafted in 1787. A group of lawyers and bankers met in Philadelphia under a cloak of secrecy and started drafting a document which would protect their interest and give them the right to tax people in an unlimited fashion, and also give them the right to raise a militia which would protect the government and suppress any insurrection or rebellion. And that is the spirit of the Second Amendment. The Second Amendment has nothing to do with individual rights of weaponry. Now, I'm all for individual rights of weaponry because I am for freedom. And I believe that freedom dictates that a man be allowed to own anything he wants to own as long as he is responsible enough to keep himself from doing harm to another person or another person's property. So, the definition of amendment. You have from Webster's, the process of altering or amending a law or document, such as the Constitution, by parliamentary or constitutional procedure. So, an amendment is the process of altering or amending. So, basically, if you go to the definition, another definition, which is being borrowed from Encyclopedia Britannica, but appears in Wikipedia. An amendment is a formal or official change made to a law, contract, constitution, or other legal document. It is based on the verb to amend, which means to change for better. Amendments can add, remove, or update parts of these agreements. So, as quickly as an amendment can be added to a document, it can also be taken away. So don't allow your freedom to rest on an amendment. Don't allow your freedom to rest on any piece of paper. There is no piece of paper, there is no body of men who can protect your rights. Your rights are your responsibility. Individual freedoms are the responsibility of the individual. And those who truly love freedom do not need a piece of paper to protect their freedom. They will protect their freedom from a fervent heart. So we have James Madison. He was involved in drafting the Bill of Rights, and he is erroneously called the father of the Constitution. However, he was not the father of the U.S. Constitution. That title belongs to George Clymer, who was instrumental in drafting the Philadelphia document. And George Clymer was a banker. I believe he was a banker and an attorney. That right there should be a red flag. Bankers and attorneys meeting to form a government, and they're meeting behind closed doors to form this government. And later on, when some of the notes were being released from the proceedings, very few actually survived. But when some of the notes were being released, it revealed that this meeting of these men served one purpose, and that was to protect their interest in their wealth and give them the power to control the new country and to tax the new country. So Madison was careful to word the Second Amendment in a way to where it would not contradict the Constitution. Article 1, Section 8, Clauses 15 and 16. We'll go there right now. If you go down, we're in Article 1 here, go down to Section 8, 15 and 16, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Suppress insurrections or rebellion, such as Shays' Rebellion, which I'm going to touch on in a minute. To provide for organizing, arming, and disciplining the militia. So, organizing and disciplining the militia, well regulated, and for governing such part of them, governing, well regulated, such part of them as may be employed in the service of the United States. So, when Madison, now he was involved in the amendment process, drafting the amendments, some of the amendments, the Second Amendment he did draft, and he was under pressure to draft it by a group of Baptists in the South who believed in the right to bear arms for purposes of self-defense. However, Madison did not go that far in drafting the Second Amendment. He kept with the spirit of Article 1, Section 8, Clauses 15 and 16, to where it would be a well-regulated militia to serve to defend the state. Now, if we look at Shays' Rebellion, Shays' Rebellion in August 1786, Revolutionary War veteran, actually War of Independence veteran, Daniel Shay led an army rebellion in Springfield, Massachusetts to protest what he perceived as the unjust economic policies and political corruption of the Massachusetts state legislature. Shay's rebellion exposed the weakness of the government under the Articles of Confederation and led many, including George Washington. Now, it was Madison and Hamilton that actually talked Washington in to attending the Constitutional Convention. He showed up in pomp and circumstance with his army, and then he wound up being basically the security detail, him and his army, for the Constitutional Convention. Anyway, we'll get into more about George Washington later, but he was not a good man. To call for strengthening the federal government in order to put down future uprisings. So it led these people to call for the strengthening of the federal government in order to put down future uprisings. They were worried about more rebellions because they knew they had more taxes in store. The rebellion, which revived the rhetoric of the American Revolution or War for Independence, shaped debate over the proper scope and authority of the U.S. government that ultimately resulted in the creation of the United States Constitution. And why I changed that word revolution or revolutionary to War of Independence, they did not overthrow the crown. Great Britain was still a country. What happened was the 13 colonies sought their independence. It was a war for independence. It was not a revolutionary war. They did not seek to overthrow the crown. So anyway, Shays' rebellion was just one in a number of rebellions during that time period. So you had Shays' rebellion taking place, and they were rebelling against taxation. It says here what he perceived as the unjust economic policies and political corruption of the state legislature of Massachusetts, but it was a rebellion over taxation. Now, there had been many rebellions over taxation. When the Continental Congress, one of their first acts was to tax the men who fought in the War for Independence. Now, they had paid these men in government script. And when the men who had fought in the War for Independence tried to pay their taxes in the government script, which the government had issued to them, the government said, no, we want to be paid in silver and gold. When the men could not pay in silver or gold, because they couldn't trade this worthless script for silver or gold, the Continental Congress of the time started confiscating the lands and farms of these men in order to collect on the taxes. That's your Continental Congress, which was operating under the Articles of Confederation. Nothing more than a band of robbers. So you had rebellion over that. Then you also had the Whiskey Rebellion. George Washington, one of the first acts as president that he committed to was to tax whiskey at such a high rate it put his competition out of business. And it also hurt people who were using whiskey as currency. Now, when he found out about some of the people in Ohio who were his competitors, who were not paying the tax, who were threatening his livelihood, his wealth, his interest, he sent an army into Ohio under the guise of fighting the Native Americans to kill his competition. This is your wonderful government of the framers. I dare not call them founding fathers. Sometimes when I'm reading an article, I'll read that term, but they were not founding fathers. So you have Shays' rebellion leading to these people wanting to get together and create a government which could enforce law of taxation. So we're going to look at the Second Amendment here. And it says a well-regulated militia. Well-regulated, a governed militia. Now, how do people today get from these four words, a well-regulated militia, the exact opposite? How do people think that this means an unregulated militia? Now, once again, I believe in everyone's right to own any weapon they want to own. If it's a 50 caliber BMG which is fully automatic, so be it, as long as they use it responsibly and are not harming the life or property of another person. So, this well regulated militia is going to be necessary to the security of a free state. Now, if you go back to George Washington's letter for a minute, you'll find that he talks about the Constitution, that it may promote, now this is Constitution, not the Bill of Rights, that it may promote the lasting welfare of that country so dear to us all, or the state so dear to us all, and secure her freedom and happiness is our most ardent wish. So we're talking about the state, we're talking about the government. So a well regulated or controlled militia, not an unregulated militia, but a well regulated militia, and we're going to get into that in a minute, being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Why would it not be infringed? So they could secure the free state, so they could be part of a well regulated militia. And it was so well regulated that there were restrictions on weapon ownership. Not only restrictions, but you had to register your weapons. Now, that was somewhat of a two-edged sword. They wanted to make sure that people had weapons, at least one weapon, in their possession so that they could be part of this well regulated militia to protect the free state from any type of rebellion, such as Shays' Rebellion, such as the different tax rebellions which took place between 1776 and 1787. So, Madison, who wrote the Second Amendment, how did James Madison, how did James Madison look at the Second Amendment? Well, let's take a quick gander here. The debate about gun control and the Constitution was a headache for James Madison. He set out to make both the Federalist and Anti-Federalist happy and consequently upset both groups. The debates are well known, and I'm not going to delve into them in this post. However, what I hope to achieve in this post is to provide two snapshots into the mind of James Madison and his evolving views of gun control. The first when he was a 34-year-old state legislator, and the second when he was the 58-year-old president. In 1785, Madison twice submitted a bill to the Virginia General Assembly entitled "A Bill for the Preservation of Deer." Both times the House failed to act. Not surprisingly, Madison wanted to financially penalize people who hunted out of season. But what is surprising is that Madison revealed his understanding of how gun usage should be distinguished between personal use and common defense. Madison's position is highlighted in the bill's language. The law would penalize people who shall bear a gun out of his enclosed ground unless while performing military duty or showing up for a muster. A muster is an inspection. In Madison's mind, there was a difference between bearing a gun for personal use and bearing arms for defense, and the state had the right to regulate the personal use of guns. So, when you talk about the Virginia rally and how Northam said no guns on the Capitol grounds, Madison would have been in favor of that. He would have sided with Northam. Don't tell me he wouldn't. I am not going to buy that BS. So, Madison believed Virginia had the right to control guns used for hunting and personal reasons. Madison's stance on gun control is further highlighted during his presidency, the Rittenhouse Affair. In 1778, during the American Revolution, a British ship called the Active carried American prisoners, including Gideon Olmsted. Olmsted organized the prisoners, and they took control of the ship and started to sail to an American port where they were overtaken by an American privateer. Both Gideon and the privateer both claimed the ship's contents as theirs. A court case followed, and Pennsylvania's Court of Admiralty determined that Olmsted was not in full control of the active when the privateer found the ship. Therefore, the court split the prize four ways. Olmsted appealed to the Continental Congress, who ruled in his favor, but Pennsylvania resisted and ignored Congress's ruling. Pennsylvania took the portion of the money they thought belonged to Olmsted and ordered the state treasurer, David Rittenhouse, to hold it in bond. Rittenhouse died in 1796 before the case was resolved, and the bond was inherited by his daughters. In 1803, a federal judge ordered Pennsylvania to give the money to Olmsted, and the state refused. In 1809, the U.S. Supreme Court ordered the federal court in Pennsylvania to enforce the 1803 decision. Federal marshals were sent to collect the prize money from Rittenhouse's daughters and were twice met by armed members of the Pennsylvania State Militia who prevented the enforcement of the Supreme Court's ruling. The governor of Pennsylvania appealed to President James Madison, hoping that the author of Virginia's resolutions would side with state power. Madison responded that he was bound by the Constitution. He was bound by the Constitution to side with the Supreme Court. Meanwhile, the federal marshal somehow got around the militia and arrested one of the Rittenhouse daughters. Another court case emerged. A portion of the new court case explored the role of the armed state militia resisting the federal government. After all, Pennsylvania exercised veto power over the federal government via the gun. Pennsylvania defended herself in part, arguing the constitutional right of armed resistance. Now, this is where it gets interesting. The U.S. Attorney, and therefore James Madison, responded that violence against the United States government was the same as rebellion. Remember Shays' Rebellion? It was the same as rebellion and revolution. There was no constitutional right to armed resistance. A lot of people believe that the Second Amendment gives you the right to armed resistance against the government. No, not so. The Second Amendment serves to protect the government from any armed resistance. There was no constitutional right to armed resistance. The jury agreed with Madison and his U.S. attorney. The case meant that Madison's government did not believe in the right to armed resistance, and therefore the Second Amendment was not about states being armed to fight off a tyrannical government. No, in fact, if the government became tyrannical, that Second Amendment was to provide an army to protect that tyrannical government. And that's the facts. So what? So in these two snapshots, we see James Madison, one of the principal architects of the Constitution, the Bill of Rights, argue that the state governments have the right to control guns outside of military militia use, and the state doesn't have the right to armed resistance against federal authority. Okay, so if we look further into James Madison's mind and Thomas Jefferson's, we'll find something rather interesting. In October of 1824, Thomas Jefferson and James Madison attended a board meeting of the University of Virginia, which would open the following spring. Jefferson and Madison had spent not a little time thinking about individual liberties, but minutes from the meeting show that their new school would not extend right to bear arms to its red brick grounds. No student shall within the precincts of the university introduce, keep, or use any spirituous or vinous liquors, keep or use weapons or arms of any kind, the board declared. So, James Madison and Thomas Jefferson did not believe that students should be able to carry weapons on college campuses. So you have a lot of evidence here that shows that the Second Amendment was not just a carte blanche right to own any type of weapon. We've actually come a long way from the founding of the country as far as weapons rights are concerned. We have more now than we did in the past. Now they're trying to chip away and take those away, and I don't agree with that. But we've got to get rid of this Constitution, and we've got to get rid of the mindset that people have to think that the Constitution is going to protect them, because the Constitution is only as powerful as the overseen body, which is the government that the Constitution created. And through judicial review, the opinion of just 5 people on the Supreme Court, any law can be overturned and any right can be attacked. And freedom is being attacked. And freedom and government cannot coexist. They can never coexist. They never have been able to coexist. Freedoms are always under attack when there is a central government. When there is a government of any kind, freedom will be under attack. And the only way we can have true freedom is to abolish government. That's the only way. And true freedom doesn't need a piece of paper to defend it or protect people from tyranny. What protects people from tyranny is a heart that loves freedom and a mind that's set on freedom, not a piece of paper. Oaths to the Constitution mean absolutely nothing. And when it talks about enemies, both foreign and domestic, it's talking about domestic enemies such as Daniel Shea of Shea's Rebellion and the men who fought with him, who were fed up with the tyrannical practices of the state government at the time. So if we go to Fordham Law Review, gun rights legal scholars have made a number of remarkable, almost phantasmagorical claims about the meaning of the term well-regulated. Perhaps the most far-fetched of these is the suggestion that well-regulated did not mean government-controlled, but only properly disciplined and drilled. In the view of Don Cates and Randy Barnett, it makes no sense to read the Second Amendment as authorizing regulation of arms. The authors of this curious interpretation of the Second Amendment have constructed a fantasy world where words mean their opposite and regulation is really anti-regulation. This version of early American history more resembles the bizarro world described in Superman comic books and rendered in hilarious terms in America's best-loved postmodern situation comedy Seinfeld than it does the constitutional thought of the founding era. After reading bizarre claims like this, one can readily understand why historian Jack Rakove has likened the world of the Second Amendment scholarship to scholarly Twilight Zone arguments, such as those of Cates and Barnett, are an example of history extra light. So that's the question that I ask. How can you take well-regulated to mean the opposite, to mean anti-regulation? And reading on, there were a variety of laws regulating firearms, and they were already in place during the founding era. Militia regulations were the most common form of laws pertaining to firearms. Such laws could be quite intrusive, allowing government not only to keep track of who had firearms, but requiring them to report for a muster would be an inspection, or face stiff penalties. Regulations governing the storage of gunpowder were also common. States prohibited the use of firearms on certain occasions and in certain locations. A variety of race-based exclusions disarmed slaves and, in some cases, free blacks. Loyalty oaths also disarmed portions of the population during the founding era. This pattern of regulation shifted dramatically in the decades after the adoption of the Second Amendment. It says, in the years after the War of 1812, a number of states enacted laws against the practice of carrying concealed weapons. So many states today have been able to fight to get that right. The first laws were passed in southern states, but Midwestern states such as Indiana also passed similar laws. The first round of laws made it a crime to carry such a weapon. Later, several states enacted even more stringent laws banning the sale of concealed weapons. So 18th century statutes regulating the use of firearms can be classified as followed. Statutes providing for the confiscation of firearms from persons unwilling to take an oath of allegiance to the state. States regulating the use of firearms within the context of militia obligations, and statutes regulating the storage of gunpowder. A smaller number of laws also regulated hunting and the discharge of firearms in certain places. These statutes make it clear that regulation of firearms is hardly a modern invention. And I'm going to read this about loyalty oaths. During the American Revolution, several states passed laws providing for the confiscation of weapons owned by persons refusing to swear an oath of allegiance to the state or the United States. To deal with the potential threat coming from armed citizens who remain loyal to Great Britain, states took the obvious precaution of disarming these persons. They didn't believe in the freedom that these people should have had. They were taking away their freedom. It didn't matter if these people lived here and had a loyalty to Great Britain. They should not have had their arms confiscated from them. They should not have had their weapons confiscated from them. It doesn't matter who you have, what group you have allegiance to. Your freedoms should not be infringed just because you sympathize with a certain group. As long as you do no harm to another person or another person's property, you can own weaponry, any weaponry you want to own. So, the government in the beginning, in the founding era, was not about individual freedoms, was not about the individual right to bear weapons. So, states took the obvious precaution of disarming these persons. Thus, the security of the community outweighed any right a person might have to possess firearms. So, see, it's nothing new when you have wording like this. The security of the community outweighed any right a person might have to possess a firearm. We hear that all the time as they're trying to take away guns now. That, well, the security of the community, the children, we need to protect the children. We need to protect the community. So we need to get weapons out of the hands of criminals, when all they're trying to do is get weapons out of the hands of free men. They're not concerned with the criminals. The criminals are on the side of government, whether they know it or not. Free men stand opposed to government. True free men stand opposed to government. If you say you love the Constitution, you're not a true free man. Can't convince me you are. In Pennsylvania, if a person refused or neglected to take the oath of affirmation of allegiance to the state, he was required to deliver up his arms to agents of the state, and he was not permitted to carry any arms about his person or keep any arms or ammunition in his house or elsewhere. Talk about an assault on freedom. Such a broad provision effectively eliminated the opportunity for someone to violently protest the actions of the Pennsylvania government or defend himself with a firearm. It should be understood that those refusing to take the oath or affirmation were unable to borrow or even use another person's firearms. Now, if we go here, it says, for centuries, Americans had accepted and even promoted strict gun control laws. During the War for Independence period, for instance, the colonists heavily regulated firearms within a militia structure. Service was mandatory, and the militias were made up of white male landowners who were required to carry and obtain their own firearms. Guns they used to strip Native Americans of their land and rule enslaved Africans. To facilitate this dirty work and ensure that guns did not fall into the wrong hands, early Americans employed stringent gun regulations. The early colonies required that guns be registered and inspected. Regulation of firearms in the colonies both during and after independence included policing powers over non-military use of the weapons. Colonial governments tracked citizens' firearms, and militiamen faced stiff penalties if they failed to report to muster. While many individual colonies had rules governing the storage of gunpowder, some regulations went even further. Boston residents were not permitted to store a loaded firearm in their home, and individuals faced stiff penalties for violating this prohibition. Boston, along with New York, prohibited the firing of guns within the city limits. Rhode Island conducted a house-by-house census of gun owners. Pennsylvania law allowed the government to disarm individuals deemed insufficiently loyal to the state. Also, I want to go to the Bill of Rights here, and one thing that we have, see, the federal government cannot guarantee a right that the state will not give. In the 10th Amendment, it says the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. And the people means body politic. We went over that in the last episode. So that leaves a lot of power in the hands of these state governments. And when you have state governments passing laws that restrict gun ownership, you can't say that it's unconstitutional. If you do, you don't know what you're talking about. Because the Constitution was created to form a strong central government that had the right and power of unlimited taxation, and the militia, the right to raise up a militia to enforce those laws and collect those taxes, just like Patrick Henry said in his speech before the Virginia Ratifying Convention. He said, you're going to have state sheriffs and federal sheriffs going around collecting taxes now. And he was against both. So, about 41 minutes here, be about 45 before we're done. But I hope that people will stop, that they will not enter into the mode of cognitive dissonance and say, oh, you don't know what you're talking about. Because I do, and I've given you the evidence. Now, what you do with the evidence, if you choose to, put on that cognitive dissonance helmet, or if you choose not to think critically about what you have been presented here, that's on you. And I don't care, and I don't care about your comments. People can comment all they want, and they can throw these erroneous quotes at me that supposedly founding fathers said. And, well, and, I'm going to go to that real quick before I end. Famous pro-gun quotes falsely attributed to our founding fathers. The people will not understand the importance of the Second Amendment until it is too late. Falsely attributed to Thomas Jefferson. He never said that. When the government fears the people, there is liberty. When the people fear the government, there is tyranny. Falsely attributed to either Thomas Jefferson, Thomas Paine, or Samuel Adams. Neither one ever said it. I've checked, and this is from the Federalist Papers. Firearms stand next in importance to the Constitution itself. They are the American people's liberty's teeth and keystone under independence. The church, the plow, the prairie wagon, and the citizen's firearms are indelibly related. BS. Washington never said it. I used to have a shirt that said that, and I felt so terrible about wearing that shirt around after I found out that the quote did not come from George Washington. And then I was also ashamed even having a shirt with the name George Washington on it after I found out what a tyrant he was. The strongest reason for the people to retain the right to keep and bear arms is, as a last resort, to protect themselves against tyranny and government. Falsely attributed to Thomas Jefferson, he never said that. The right of the citizens to bear arms in defense of themselves and the state shall not be questioned. Falsely attributed to John Madison. Probably James Madison. And we know that James Madison was not about people defending themselves or even hunting. And hunting is a part of defense. You're feeding your family. Arms in the hands of the citizens may be used at individual discretion for the defense of the country, the overthrow of tyranny, or private self-defense. Falsely attributed to John Adams. The best we can help for concerning the people at large is that they be properly armed. Falsely attributed to Alexander Hamilton. Those who hammer their guns into plowshares will plow for those who do not. Falsely attributed to Thomas Jefferson. Eternal vigilance is the price of liberty. Falsely attributed to Jefferson or Patrick Henry. So, actual gun quotes talk about militia, talk about that the people need to be armed, they need to be well, you know, uh, trained in safety, and it talks about military, talks about militia. So people need to think critically about this. And the reason I come at the Second Amendment and the reason I come at the Constitution so hard is because it is a weed which resembles a fruit bearing plant. And in the Garden of Freedom, no weeds are allowed. If you're going to allow weeds in the Garden of Freedom, then you're not really a gardener in that Garden of Freedom. You're not really one who cares for the garden. If you're going to allow something to grow which can actually take away freedom and destroy your freedom and the freedom of your fellow human beings. So, anyway, I just wanted to get that out there. This is not the last time I'm going to be talking about the Constitution or the Second Amendment. I'll be going over this many times because we need to pull the weeds. We need to fight against anything which is a threat to our freedom. And I'm here to tell you, and if you don't believe me now, hopefully you'll believe me in the future. The Constitution is a threat to freedom. Freedom comes from here, not a piece of paper. A piece of paper doesn't protect you, doesn't protect your freedoms. Your freedoms are only protected by you. If you have the intestinal fortitude to protect your freedoms, then your freedoms will exist. You'll at least die a free man defending your freedoms, and you'll never live as a slave or be accused of living as a slave. Freedom comes from here. It comes from the heart. This is William Moore. Love each and every one of you. Thanks for tuning in to Beyond the Ties That Bind. Until next time, peace.